The first 10 amendments to the Constitution are called the Bill of Rights. They were written to ensure that the fundamental rights of all Americans would be protected. But the Bill of Rights only applied to actions by the federal government. State governments were not obligated to uphold those rights or limited by their restrictions. In fact, until 1833, Massachusetts had a public worship tax, which was used to pay ministers and support Protestant churches in that state. That tax would be in violation of the First Amendment, which says, "Congress shall make no law respecting an establishment of religion." But the restriction was only on Congress, not state governments. Chief Justice John Marshall made that clear in a decision he wrote in 1833. The Constitution, he said, was ordained and established by the people of the United States for themselves and not for the government of the individual states. In the aftermath of the Civil War, Southern states passed laws restricting the rights of newly freed slaves. To counter this, Congress proposed the 14th Amendment. It was ratified in 1868. The first section of the 14th Amendment grants citizenship to all native-born people, including former slaves, and lists 3 clauses which limit the power of state governments to interfere with the rights of American citizens. The clauses are the Privileges and Immunity Clause, the Equal Protection Clause, and the Due Process Clause. In 1873, the Supreme Court issued the first ruling involving the 14th Amendment. It was the Slaughterhouse Cases, which challenged a Louisiana law granting a monopoly to one business, thereby interfering with the rights of other business owners. Those businessmen claimed that under the Privileges and Immunity Clause of the 14th Amendment, their rights were being denied. The court refused to accept that argument. It ruled that the 14th Amendment did not apply because it only concerned privileges and immunities that came with being a citizen of the United States, not the citizen of a state. And the privileges and immunities of American citizenship, the court said, were only those written into the Constitution. For many years, that was how the 14th Amendment was interpreted. But slowly, there was a change in the court's thinking. In 1925, in the case of Gideon versus New York, the Supreme Court stated for the first time that freedom of speech and freedom of the press, rights guaranteed by the First Amendment, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. Some justices thought this opinion meant that all the rights guaranteed by the Bill of Rights should be extended to actions of the state. They advocated a policy known as total incorporation, meaning that under the Due Process Clause of the 14th Amendment, the entire Bill of Rights automatically became binding on the states. But the Supreme Court rejected that view and instead adopted a policy known as Selective Incorporation, or the Incorporation Doctrine. Using Selective Incorporation, the court has decided over time and case by case which provisions of the Bill of Rights will extend to the states. In 1937, in the case Palco versus Connecticut, the Supreme Court set out the standard for selective incorporation. The standard, the court said, would be to apply to the states any right so rooted in the traditions and conscience of our people as to be ranked as fundamental. In the 1950s and the 1960s, under the leadership of Chief Justice Earl Warren, the Supreme Court incorporated almost all of the first 8 amendments of the Bill of Rights using the Due Process Clause of the 14th Amendment. For example, in 1962, in the case Engel versus Vitale, the court ruled that the state-sponsored prayer in public schools violated the First Amendment protection against the establishment of religion. In 1963, in Gideon versus Wainwright, the court ruled that not providing legal counsel to poor defendants in felony cases violated the Sixth Amendment right to counsel. In 1966, in Miranda versus Arizona, the court ruled that not notifying suspects of their rights before interrogations violated the Fifth Amendment. Since then, other rights have been incorporated. In 2010, in the case McDonald versus Chicago, the Second Amendment right to bear arms was extended to the states. With the exception of the Third Amendment, prohibiting the government from quartering soldiers in private homes, all of the first 8 amendments of the Bill of Rights have been completely or partially incorporated. The exceptions are the Fifth Amendment right to indictment by a grand jury, the Sixth Amendment right to a jury selected from residents of a crime location, the Seventh Amendment right to a jury trial in civil cases, and the Eighth Amendment prohibition against excessive fines. The prohibition of excessive bail, however, has been incorporated. The Constitution that we live by today was not the nation's first Constitution. The first Constitution was called the Articles of Confederation. It was a loose association of strong independent states with a weak central government. Almost from the outset, it was seen as ineffective. So the leaders of the new nation created a new constitution, one in which the federal government and the state governments shared some powers, but which made the laws passed by federal government supreme over the states. Written into the Constitution are directions for that division of power. Article 6, Section 2 of the Constitution is called the Supremacy Clause. It states that the Constitution and the laws passed by Congress are the supreme law of the land, and that judges in the individual states are bound to adhere to those laws and the judgments of the Supreme Court. Article 4, Section 2 is called the Full Faith and Credit Clause. Its purpose is to ensure that judicial proceedings in one state will be respected by all states. For example, if a person from Florida is involved in a car accident in Georgia, the Supreme Court can force Florida to hear the case, even though it originated in Georgia. Also included in Article 4, Section 2 is the Privileges and Immunities Clause. This clause protects the fundamental rights of individual citizens in any state and restrains any state from discriminating against out-of-state citizens. Article 1, Section 8 is called the Commerce Clause. This clause gives Congress the power to regulate commerce with foreign nations and among several states, and with Indian tribes. However, because the word commerce has different meanings, the clause was left to interpretation. As with so many other issues, decisions of the Supreme Court have shaped the understanding of the Commerce Clause. The first decision came in 1824 in the case of Gibbons versus Ogden. New York State had given Aaron Ogden, a steamship operator, an exclusive license to operate ferries between New York and New Jersey. Thomas Gibbons, another steamship operator, also ran ferries along that route. When he was denied access to these waterways, he sued Ogden. New York State ruled in favor of Ogden, but Gibbons continued his fight. Eventually, the case reached the Supreme Court. The court reversed the decision. In doing so, Chief Justice John Marshall pointed to the Federal Licensing Act of 1793, which gave Congress, not the state of New York, the right to regulate commerce that crossed state lines. And the ruling defined commerce as not just articles in trade, but as any dealings between states. That decision has affected many, many issues in which state lines are crossed. Another important decision came in 1819 in the case of McCulloch versus Maryland. James McCulloch was the head cashier at the Second Bank of the United States in Maryland. The Second National Bank had been established by an act of Congress. The state imposed a tax on the bank, but McCulloch refused to pay it. The case was brought to the Supreme Court, which ruled that under the Necessary and Proper Clause of Article 1, Section 8 of the Constitution, Congress had implied powers to create the bank and that the state of Maryland lacked the power to tax it. The tax, the court said, was unconstitutional because a state cannot impede constitutional federal laws. To this day, this case remains one of the most important in the history of the Supreme Court. While the Constitution gives certain powers to the individual states, it is essential that the states work together to attain common goals. For example, the Port Authority of New York and New Jersey oversees the complex system of bridges, highways, and other transportation infrastructures in the New York and New Jersey area. This essential organization was established by the two states through an interstate compact and authorized by Congress. However, from time to time, states may have disagreements. If they can't be settled outside the legal system, Article 3, Section 2 of the Constitution states that the Supreme Court has exclusive jurisdiction to decide the case in order to ensure a fair decision. The federal government can also use other means to exert influence over the states, like offering grants and funds. For example, in 1984, Congress passed the National Minimum Drinking Age Act, which required every state to raise the minimum age for the purchase and public possession of alcohol to 21. Under the Constitution, establishing regulations like these is left to the individual states, not the federal government. But the Act stated that any state that did not comply with the law would face a reduction in highway funds from the federal government. According to the U.S. Department of Transportation, all states have complied with the law.